Yes, thank you, Mr. Chair. Just one question, Mr. Chair, to Attorney Raul Villanueva, Mr. Chair. Is he still around, Mr. Chair?
Yes,
Yes,
Your
yes,
Honor.
it's there.
Mr. Chair. Good afternoon, Your
Yes,
Honor.
good afternoon, Attorney. The title of the project did not mention the specific barangay. No, it was only the Ozamiz City was only mentioned. Now, the name Lam-An and the barangay Malaubang just came up. What if, Attorney, the congressman was the one who identified the barangay? Is it not a violation of the project identification, which is unconstitutional according to the Bilgica case of the Supreme Court?
Well, based on that premise, Your Honor, it might be there might be a violation, Your Honor, if it was a member of Congress who identified where it should go, Your Honor, and not the executive branch chief LGU, Your Honor, or mayor for that matter.
Okay, thank you, Attorney Raul. May I ask the former district engineer Abinales, Mr. Chair?
Architect, District Engineer Abinales, Caroline.
Yes, Mr. Chair, granting that it was not the congressman who identified the project after GAA, which we all know that it is a violation of the Supreme Court decision on the Belgica case. Granting, Mr. Chair, that it was the DPWH who identified the project, and I doubt about it, Mr. Chair. So are they familiar with the term realignment and modification, Mr. Chair? Can I ask the district engineer, the former district engineer, Mr. Chair?
Former District Engineer Abinales, please answer.
Yes, good afternoon po again, Your Honor. May I, pwede po yung question, sir?
Yes, are you familiar with the word realignment
Yes, sir.
of projects? Are you familiar with the word modification?
Sir.
So if the project title does not have a barangay, and you just decided that it will be in Barangay Lam-An and Barangay Malaubang, what is the proper procedure in DPWH? There was no barangay written in the GAA.
We coordinated with the LGU, sir. Ozamiz City.
You coordinated with the LGU, and then after coordinating with the LGU, you asked the LGU what was the project he wanted, even if the LGU don't want the project. So granting that you coordinated with the LGU, after coordinating with the LGU, after naming Lam-An and after naming Malaubang, what is your next move?
Oh, we conducted a preliminary and detailed engineering, sir.
Okay, Mr. Chair, I'd like to, especially if there are other DPWH employees here, I'd like to refer them to Department Order number 37, series of 2018, regarding guidance on project modification, augmentation, and realignment, Mr. Chair. Mr.
Yes.
Chair, without the name of the project, it is only the Secretary of the Department of Public Works and Highways who is allowed to modify a project, Mr. Chair. No other. If I may, Mr. Chair, I want to read to you the section B of the executive order, Mr. Chair. That number one,
Mr. Chair? Point of order, Mr. Chair.
Secretary of Public Works and Highways
Yes.
is only authorized to modify the project.
Yes,
Continue,
on
Mr.
the
Chair.
point of order, DS Oaminal.
I am raising point of order, Mr. Chair, because under our role, we can only ask questions which are germane to the subject matter, Mr. Chair. The distinguished representative of the first district of Misamis Occidental, I know what he's trying to drive out, is talking things which is not the issue of this investigation, Mr. Chair. We are not talking here of modification of project. We are not talking here of revision of the project. So with that, Mr. Chair, I am raising a point of order that the distinguished gentleman of the first district is out of order.
Mr. Chair, I am referring to the multipurpose building Lam-An project, Mr. Chair, and the multipurpose building Malaubang project, Mr. Chair, because it was not written in the General Appropriations Act. The name Lam-An and the name Malaubang was not written. So therefore, Mr. Chair, it is the guidelines of DPWH to make an realignment or a modification in order to name it to that barangay as specified, Mr. Chair. So I am specifically referring to item 19 KJ 0186, Mr. Chair.
Yes,
I am
yes,
referring to
Congressman
19 KJ
Jegotti.
0186.
Yes, noted, Congressman Jegotti, DS Oaminal, the subject of this hearing is the
Illegal demolition alleged.
not only that, we expanded the scope to 8 issues. Remember the first hearing, there were 8 issues enumerated, and the one of which is the implementation of the project. If there is malfeasance, misfeasance, or non-feasance, so we need to.
It is in the resolution, the implementation of the housing project.
The title of let me refresh the memories of the members, that the title of the project and
Resolution.
the title of the resolution is the conduct of inquiry in aid of legislation on the implementation of the housing project and the alleged violation of demolition. So the first part is on the alleged implementation of housing project. This is part of implementation. I'm not a lawyer, but this is part of implementation. So that is the answer to your point of order, DS Oaminal.
He is talking, Mr. Chair, of modification, revision.
Yes, but this is part of implementation. Once you put it inside the budget, the GAA, anything after that is already transferred to the executive department for implementation.
Mr. Chair, that's why
Mr. Chair, can I continue, Mr. Chair?
there is no issue of revision in the subject matter, Mr. Chair.
Mr. Chair,
The resolution was specific.
Can I continue, Mr. Chair?
No, because
Mr. Chair.
Mr. Chair, there is a color.
Mr. Chair, please. There is an issue of revision here because it was supposed to be 4 floors, the phase 1, and then it became 2, and then there is a plan again to make it 3. There is a subject of revision here. This is still part of the issue, Mr. Chair. Why is he being...
Yes, I have answered the point of order. I've ruled that this is part of implementation, and
Yes,
let us
Chair, thank you.
give Representative Jegotti, who waited for 5 hours his
Thank you,
time.
Mr. Chair. Thank you, Mr. Chair.
Mr. Chair.
Mr. Chair, again, Mr. Chair, if this project was identified after GAA by a congressman, it is unconstitutional, Mr. Chair, according to the Supreme Court, based on GR number 208566. But, Mr. Chair, it is if it is the DPWH who identified such barangay as Lam-An and such barangay as Malaubang, therefore, Mr. Chair, it needs a modification, Mr. Chair, and it must undergo the modification process, which I will mention one by one, Mr. Chair. If you allow me, Mr. Chair, modification or realignment.
For expediency, can you give the memorandum from the DPWH to this committee, to the Secretariat? You don't need to
Department
read
Order
it.
number 37, Mr. Chair, series of 2018.
Okay. Noted.
Section B, Mr. Chair. And section F.
Okay, noted. Thank you. We will expect the copy of that memorandum.
Last word, Mr. Chair, last manifestation. Mr. Chair, the housing project of Ozamiz City is very laudable. In fact, I am willing to copy that project, Mr. Chair. And I say yes to the right of decent housing, Mr. Chair. But with all these complaints, I also say yes to the basic adherence of the rule of law, Mr. Chair. According to Deputy Speaker Marcoleta, Mr. Chair, that the end does not justify the mean. But we have to follow the law, Mr. Chair, and modification and realignment is part of this, Mr. Chair. Thank you, Mr. Chairman.
Thank you.
And please
Noted.
consider
Noted,
executive
thank you,
order implemented.
Representative Jegoty, thank you.
Mr.
Is there
Chair,
anybody?
Mr. Chair,
Yes. Marcoleta, yes.
a few, very few questions. I think one question for the Deputy Administrator of the Supreme Court, one for the representative from the NHA, and one for the Assistant Solicitor General, Mr. Chair.
Okay, please finish up with those three questions.
Yes.
One for the Deputy Court Administrator Villanueva, sir.
Yes, Deputy
Honor, Mr. Chair.
Deputy Administrator, are you still there?
Yes, Your Honor, Mr. Chair.
During the last hearing, when I asked Engineer Hipona, why is it that despite the fact that the soil exploration already assured that the maximum capacity of that building is only for 3 floors, and I have shown a video clip, the Honorable Diaz Oaminal was promising his constituents that he will be putting another floor. And when I asked Engineer Hipona, he categorically said, gusto ito ni Congressman. At narinig yan ni Mr. Chair. Kaya kanina pa, doon niya rin tumutungo yung kanyang pagtatanong. Dinig na dinig nating lahat yon. 2 beses niyang sinabi, yun ang gusto ni Congressman. Mr. Chair, within the meaning of Belica versus Ochoa, when a member of Congress will do anything after the GAA, yung sinabi niyang gusto ni Congressman, will that be post-enactment measure, Mr. Chair? Mr. Deputy Administrator?
Your Honor, my reply is based on the premises given, Your Honor. It might, yes, Your Honor, be considered a violation.
Kasi yun ang gusto niya, sabi niya. Sa mga tweet, meron pa siyang impluensya kung saan patungo yung direction ng implementation ng building. Tama?
Yes, Your Honor. That is the statement, Your Honor. Yes.
That was the statement, and you were there also, and I think you heard the engineer saying, ito ang gusto ni Congressman, twice nating narinig. Mr. Chair, I will go now to the representative from the NHA. Salamat, Deputy Administrator.
Thank you, Your Honor. Thank you rin po.
Representative from the Attorney Carlo.
Good afternoon, Your Honor.
Good afternoon. Pasensya na at binalikan kita uli kasi ang pinag-uusapan na issue yung tungkol sa insight development. May sinasabi ka kanina justifying that under 7279 pwedeng gumawa o pwedeng kunin pwedeng i-develop ng LGU, something like that. You said that, right?
Yes, Your Honor. If it's
what exactly is the provision in 7279 are you referring to?
Section 9, Your Honor, the priorities of the acquisition of land, because we're talking about the order of priority, why the local government directly expropriate the property. So if it's an on-site, Your Honor, there's a provision in 7279 that the priorities can be not applied to the case, Your Honor.
In this particular case, you were saying that Republic Act 7279 did not apply. Which particular part of Section 9 of 7279 are you referring to?
The last part, Your Honor, the last paragraph, it says that where on-site development is found more practicable and advantageous to the beneficiaries, the priorities mentioned in this section shall not apply, Your Honor.
Will you please read that, Sir Representative?
In Section 9, Your Honors, the priorities in the acquisition of land, lands for social housing should be acquired in the following order. And the last provision of that, Your Honor,
yes.
The last paragraph says that where on-site development is found more practicable and advantageous to the beneficiaries, the priorities mentioned in this section shall not apply.
Okay, so you're talking here of the advantages to the beneficiaries. But if the area to be covered by that particular project are titled properties, naturally the beneficiaries are not the ones are not the owners of the property expropriated. Is that correct?
Again, Your Honor.
Kung yung lupa, sabi mo, the on-site development is more practicable and advantageous to the beneficiaries, the priorities mentioned in this section shall not apply.
Yes, Your Honor.
Okay. Ang problema dito, ang magiging beneficiaries, ang tinutukoy lang. What about the owners of the titled lots where their areas were utilized to give up that site development for the beneficiaries? What is the position of NHA there? Will you allow the acquisition of private lands for purposes of providing certain beneficiaries housing for them, but again, the residents who own the houses and who built them with their income, hard-earned income, ano magiging katayuan nila rito? You are applying this particular last paragraph not for the benefit of the landowners, but you are talking only for the benefits. Is that the position of the National Housing Authority? That the residents who owns the titled properties will be disadvantaged for the sake of would-be beneficiaries? Will that be the position of the National Housing Authority?
Your Honor, that is based on the premise that the beneficiary of the housing is those who are presently occupying, Your Honor.
Yes. Kung sila yung nag-occupy. But if the area over which the buildings will be built are not the beneficiaries but other people who own the lots, this particular paragraph will not apply. Is it not?
I think in this case, Your Honor, the beneficiaries are also some of the landowners, Your Honor.
Not necessarily. You don't know that because you have not studied this. If they were beneficiaries in the first place, they should not have gone to court to question this. Sila ang magbe-benefit, di ba? It's very obvious that the beneficiaries here are not the ones, okay, located or living in the on-site development. They are not. They don't own the property. The residents who own the properties will be disadvantaged by this. Hindi naman sila informal settlers. This particular paragraph refers to informal settlers. Attorney Carlo, ang pinag-uusapan sa Lam-An ay yung residente na sila ang may-ari ng lupa. Then you cannot apply this. Kaya nga makikita mo under Section 9, under Section 9, titingnan mo riyan, the private-owned lands are last in the priority. You will have to consider the order of priority before you apply this last paragraph. Kasi ang last paragraph refers to the informal settlers who are living on site. Yun ang ibig sabihin nun. Ikaw naman.
I'm not aware, Your Honor, because there's no mention in the law, Your Honor. So I'm just reading it as is, Your Honor.
I assume that you have already studied the case in Lam-An. Hindi mismo beneficiaries yung pagde-developan ng on-site. They are titled lots owned by the residents. Hindi yung mga informal settlers.
Yes, Marcoleta, let us move on.
Okay.
The witness is
Thank
ready.
you for having clarified that, Mr. Chair. I will now go to the last person. I would like to query on the Assistant Solicitor General.
Yes, Attorney Panga, Assistant Solgen.
Yes, Mr. Chair, Your Honor, present.
Attorney, pasensya na, at medyo humaba na naman tayo. Kanina sinabi mo that if the court issued a writ of possession, even without a writ of demolition, the proponent of the project can already demolish structures or houses or whatever found there dahil binigyan siya ng writ of possession ng court. Tama ba yun?
Mr. Chair, Your Honor, what I said was, once the court issues a writ of possession, the implementing agency can implement that. I also said that depending on the situation, a writ of demolition may or may not be required.
The situation, attorney, is that most of the area covered by the two buildings are owned by small landowners. They're titled lots, and their houses are built in those areas. That is the reason why they questioned this project in court, and they went up to the Supreme Court to defend their rights. Now, given this situation, pwede mo bang sabihin that because the court issued a writ of possession, pwede nang gibain without writ of demolition yung kani-kanilang bahay? This is now the concrete situation in Lam-An.
Your Honor, my understanding of the law is that the writ of demolition does not apply to properties expropriated against property owners. In other words, if we expropriate a land owned by Mr. A, we can demolish the improvements provided we are issued a writ of possession. But the law says that if the area, whether owned by A or B, is occupied by informal settlers, then the law requires a writ of demolition if they refuse to remove their structures, even if a writ of possession has already been issued by the court.
Attorney, I will explain it again for clarity. Yung pinagtayuan ng dalawang buildings, hindi informal settlers ang nakatira doon eh. Yung mga nagsipag-complain doon, titled yung kanilang properties over which those residents were built. Yung iba, renters pa nung isang structure doon, and I have documents to show because I have the receipts and proofs of their rental and lease payments, hindi sila informal settlers. Ngayon, ang sinabi mo kasi kanina, kapag meron ng writ of possession, ay pwede nang mag-demolish yung proponent even without a demolition order coming from the court. That's a very dangerous position, attorney. I wanted to ask you what legal basis are you using
Your Honor,
by articulating that a very, very dangerous proposition?
Mr. Chair, Your Honor, I am simply basing my statement on Section 9 of Republic Act 10752. It says here that if the land subject of the expropriation involves informal settlers, then the second paragraph requires a writ of demolition if the informal settlers refuse or are unable to demolish their structures and other improvements despite the writ of possession issued by the court. If there are no informal settlers involved, my position is there is no need for a writ of demolition as long as you have a writ of possession. The basis for this is that the writ of possession will not be issued by the court unless requirements on the deposit shall have been made.
The problem, attorney, is that hindi informal settlers ang pinag-uusapan natin, but these are residential areas titled sa kanilang pangalan yung kanilang lupa na kinatitirikan. So, ang yung binabanggit involves informal settlers. We're not talking of informal settlers here. These are titled lots of residents in Barangay Lam-An. Yung mga bahay nila dyan, merong writ of possession pero walang writ of demolition, meron ng tinanggal, meron ng winasak. Ang tanong ko sa iyo, kasi kung sasabihin mo na hindi ka kailanganin ang demolition order dito, that is a very, very dangerous statement. Kasi kapag ka pala nakuha ng proponent o LGU, kahit anong nakakuha siya ng writ of possession, hindi naman siya informal settler, titled sa kanyang property, then they can readily demolish that structure. Is that your position?
Mr. Chair, Your Honor, my premise on that is that there is no need to issue a writ of demolition if the property which is expropriated, subject of the writ of possession, has been, the deposit requirement rather, has been made with the court. The court will not issue a writ of possession if those deposit requirements are not complied with. In other words, the minimum is, if it were a lot or if there is an improvement, the requirement on the deposit shall be made so that from the get-go, the land and the improvement is already been paid by the agency, and after the writ of possession shall have been issued, then the agency can already carry out the writ of possession. They can clear the area, start the right-of-way project. The reason why I mentioned writ of demolition involving informal settlers, because that's the only time in the Right-of-Way Act under Section 9 that the writ of demolition was mentioned. And that writ is required.
Ganito kaya medyo hindi tayo magkaintindihan ganito eh. You're assuming that because the court already issued the writ of possession, the deposits required under Republic Act 10752 have been completely deposited, complied with. Hindi ganoon ang nangyari as testified to by the clerk of court. Sa mga tweet, walang nangyaring pagbabayaran, walang computation of due compensation ng property, walang replacement cost, and wala ring market value yung tungkol sa trees or plants or shrubs na naalis doon. Sa mga tweet, you already entertain and assume na nagkaroon na ng bayaran, pumayag na lahat ang mga tao, that completed already the issue, kaya nagkaroon ng writ of possession. Hindi ganun ang nangyari in this particular case. Walang ganitong nangyari. There is no regulation.
This Marcoleta, I think we will not get through anything here because the OSD already gave his stand. Let's just leave it at that.
Yes, Mr. Chair. I think it is his own interpretation, but hindi kami magkaintindihan sa facts because I think he has not taken all the facts that we have been trying to.
I think he has been here since the first hearing, and I think he
yes, precisely. I think there are facts that are not yet within his reach, Mr. Chair. Like for example, ang buong akala niya puro informal settlers yung nandun, and he did not realize that there are title properties involved here.
My interpretation of his answer is, if there are no informal settlers involved, there is no need for the writ of demolition. The writ of demolition is only needed when there are informal settlers involved in that particular case. So I think let's just take his, we cannot berate him to produce another answer. I think he has already given his final answer.
Yes, Mr. Chair, but we would like only to differentiate the situation here, because if the informal settlers are protected, I don't think the law purposely will not protect also the titled properties owned by the residents. Yun lang naman ang gusto nating i-differentiate doon, Mr. Chair. Thank you, Mr. Chair.
Will you still change your answer, or that's your final answer? Because I need to regulate this hearing so that is that your final answer already?
Mr. Chair, Your Honors, yes, I stand by my answers because I just rely on the provisions of the law, Your Honor.
Okay, thank you.
Mr. Chair, ang final manifestation ko dito, I think the representative from the Solicitor General's office must consider all the facts that we have been trying to find out in this hearing, because we are not talking only of informal settlers. There are no informal settlers in Lam-An, Mr. Chair. They are all residents. Mostly they are renters, Mr. Chair.
Noted. That's why his answer is, since there are no informal settlers, then there is no need for a writ of demolition.
So what happens to the residents who are not informal settlers when their house were demolished, Mr. Chair? That's the only question. I don't want to create the impression on the part of the Solicitor General that he can make a statement, a very dangerous statement. It is as if that the residents are not protected because the writ of demolition is no longer needed. Thank you very much, Mr. Chair.
You know, my personal opinion, the law is subject to interpretation. So he has a different interpretation from your interpretation. So I think another third party should be able to interpret your differing opinions. That's my final. That's my take on that. Because we've given this topic already around 10 minutes, and it's going around and round. That's why we need to.
I'm already finished with him, Mr. Chair.
Thank you.
Salamat, Mr. Assistant Solicitor General, for your answer.
The committee heard the positions and arguments of the sponsor, clarifications from our members, and response of our resource person. We also gathered substantial and relevant materials and documents that will be considered in the preparation of the draft committee report. To our resource persons and other parties affected by these hearings, you may still submit your respective position paper and support documents on the subject of inquiry. For some who have not submitted, it is the position of the chair that their inaction will not otherwise affect the testimonies and documents already submitted to the committee, and the information gathered will stand as part of the records of the committee. Representative, hello. Representative Gato, you're in mute. You're in mute. You're already in mute. You're in mute. Unmute yourself. Yes.
Mr. Chair,
Yes.
with the premises stated by the chairman, may I now move for the termination of the committee deliberation on House Resolution number 1197? I so move, Mr. Chair.
Second.
With the motion of Representative Jun Gato duly seconded and hearing no objection, the deliberation of House Resolution 1197 is hereby terminated.